I say it's unopposed. No one has filed a response. It's a motion to modify a default judgment that the court entered on June 17th of this year against a defendant, Jay Patel, who hasn't made an appearance. It's really straightforward. I prepared the original default judgment that you signed, and I had language in there at the very end that says all relief not requested is herein denied, or all, the basic language, right? All relief not expressly granted herein is denied. And Your Honor, I started thinking that was probably a mistake on my part. There are live defendants that we intend to go to trial against. They're represented by Mr. Yep. So I just submitted a modified default judgment that clarifies with one new sentence that all relief requested against defendant Jay Patel not expressly granted herein is denied.
Let me check one thing real quick. I don't have any problem with this if it's unopposed. Yeah, okay, your trial setting's still good.
Your Honor, I'm sorry to interrupt you. I said unopposed, but to be honest, I don't know Mr. Kip's position. I meant to say that no one has filed a response.
Okay. Do you have any opposition?
Your Honor, obviously, my clients would be glad to not be in this case anymore, but I believe that Mr. Strother's motion was in fact targeted to the single defendant, even though the order that was entered didn't fully reflect that.
Okay. Sounds good. We will go ahead and modify the default judgment. We'll make sure. I'm going to also make sure it says on the top that it's a partial default judgment, just so it doesn't get closed in the system.
In Your Honor, I know that you all have the technical ability to add that word in there. Would it be useful if I sent it?
No, I'll handwrite it in.
Okay. And Your Honor, before we're dismissed,
Sure.
My next step will be to file a motion to sever this out. Is there any procedure that the court prefers I do as far as who's severed out and what you want me to attach?
So there's not anything specific that I require, but something I've noticed that a lot of attorneys don't do correctly. And I'm not saying that you would do this, but it's just a common issue that I see that kind of is not following Supreme Court precedent, is that you have to include language in there that says that the new cause number is severed out. So you'll have to say, that I don't know if it'll be the new cause number, it will be the new cause number. If you want to have that case be the defaulted case, you'll need to say the defaulted party will be, the claims against the defaulted party will be included in DC, and then put an underline, and then you have to pay a severance fee. And a lot of people, then you also need to include that in there, is that you have to pay a severance fee. A lot of times people don't realize you have to pay a severance fee, but that my understanding is that the new judgment doesn't become final, or there's some issues about it becoming final unless you pay the severance fee. So you want to include that in the order as well. It's not something that's unique to my court. That's just how the Supreme Court has told us to do it.
Understood, Judge. Thank you.
All right. Anything else, guys?
Nothing further, Your Honor.
You guys have a great rest of your day, and we'll see you on the next one. Okay.
Thank you, Judge.
You as well.
Thank you.